Hello everybody, welcome to today's video on Fundamental Rights Part 2. Today we will be discussing Article 13 in depth. Article 13 एक बहुत ही complex article है, but this will be forming the foundation for the rest of the fundamental rights articles या तो फिर the entire constitution for that matter, क्योंकि यहाँ पे बहुत सारे definitions जो हम discuss करेंगे वो बाद में काम आएगा. But we do have a request. If you like our content, do like, share and subscribe Exact IS on YouTube and follow us on Instagram. तो चलिए शुरू करते हैं. तो ये है आर्टिकल 13 इन एंटायरटी. ये बहुत ही लेंदी सा एक आर्टिकल है, तो I'll not read it out at once. Rather, I will take each clause and we'll discuss it clause by clause. Each clause को हम डिटेल में डिस्कस करेंगे. But let us take a look at the title of the article. So Article 13 in the Constitution of India 1949 says, laws inconsistent with or in derogation of the fundamental rights. यानी जो भी laws violate करते हैं fundamental rights को, तो इन्हीं laws के बारे में बात किया गया है in this entire Article 13. तो before we look at the clauses, हमें ये समझना होगा कि आर्टिकल 13 में 3 डॉक्ट्रिन बहुत ही इम्पॉर्टेंट है जो यहाँ पे अप्लाई होते हैं. यहाँ पे आर्टिकल 13 में हम 3 डॉक्ट्रिन के बारे में बात करेंगे, डिस्कस करेंगे जो यहाँ पे अप्लाई होता है. एक है डॉक्ट्रिन ऑफ एक्लिप्स, दूसरा है डॉक्ट्रिन ऑफ सेवरेबिलिटी एंड द थर्ड इज डॉक्ट्रिन ऑफ जुडिशियल रिव्यू. Now I'll discuss this in detail in the rest of the slides. But remember that these 3 doctrines apply in Article 13. इसमें बात किया गया है. So let's take a look at Article 13 Clause 1. Article 13 Clause 1 reads as, all laws in force in the territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. Yani the entire Article 13 Clause 1 can be understood in 3 key phrases. The first one says, all laws in force in the territory of India immediately before the commencement of this Constitution. We'll discuss all laws in force later, but what we need to understand is this particular phrase talks about pre-constitutional laws. यानी बिफोर द इनैक्टमेंट एंड एनफोर्समेंट ऑफ द कॉन्स्टिट्यूशन, ब्रिटिश एरा में जितने भी लॉज वेर पास्ड, सच एज इंडियन पीनल कोड 1860 या तो फिर इंडियन कॉन्ट्रैक्ट एक्ट 1872, ये सब लॉज विच केम बिफोर द इनैक्टमेंट एंड एनफोर्समेंट ऑफ कॉन्स्टिट्यूशन, ऑल दीज लॉज आर कॉल्ड प्री कॉन्स्टिट्यूशनल लॉज, क्योंकि ये कॉन्स्टिट्यूशन के पहले आए थे. So all these pre-constitutional laws, insofar as they are inconsistent with the provisions of this part indicates part 3 of the Constitution, yani the fundamental rights. So if such pre-constitutional laws do violate the provisions of fundamental rights, अगर कोई भी ऐसा law कोई भी fundamental right को violate करता है, तो they shall, to the extent of such inconsistency, be void. तो पहले एक चीज़ समझते हैं. जैसे आप देखते हैं सोलर एक्लिप्स में द मून कम्स इन बिटवीन द सन एंड द अर्थ, एंड बिकॉज ऑफ दैट द मून ओवरशैडोज द सन. सो वी ऑन अर्थ कैन नॉट सी द सन, क्योंकि मून ढक देता है सन के व्यू को. सिमिलरली अगर ऐसा कोई भी प्री कॉन्स्टिट्यूशनल लॉ है जो कि वायलेट करता है फंडामेंटल राइट्स को, तो फॉर द टाइम बीइंग इट विल बी ओवरशैडोड, इसे ढक के रख दिया जाएगा साइड में, ये फंक्शनल नहीं होगा. सोचिए कोई भी एक लॉ है, XYZ लॉ, उसमें बहुत सारे सेक्शंस हैं और उसमें से एक सेक्शन, से फॉर एग्जांपल सेक्शन 2 ऑफ दैट XYZ एक्ट, इट वायलेट्स अ पर्टिकुलर फंडामेंटल राइट. से XYZ एक्ट के सेक्शन 2 वायलेट्स आर्टिकल 21 ऑफ द कॉन्स्टिट्यूशन. तो फॉर द टाइम बीइंग Section 2 of that act will be considered void. जब तक ना कोई amendment लाया जाता है which amends either the fundamental right to make this particular provision valid, or an amendment is brought to amend section 2 of this act so as to make it consistent with the fundamental rights. या तो फिर आइदर फंडामेंटल राइट्स को अमेंड किया जाए या तो फिर इस पर्टिकुलर सेक्शन को अमेंड किया जाए ताकि वो कंसिस्टेंट हो फंडामेंटल राइट्स के साथ. अनलेस सच अमेंडमेंट इज ब्रॉट, दिस पर्टिकुलर प्रोविजन विल बी कंसिडर्ड नॉट डेड बट रैदर डॉर्मेंट, यानी इट विल नॉट बी कंसिडर्ड एकदम से इनवैलिड. But in future, with the proper amendment, such provision can be brought back to life again. So now let's take a look at Article 13 Clause 2. Article 13 Clause 2 reads as, the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall to the extent of the contravention be void. So Article 13 Clause 2 can be understood in two key phrases. First is, the state shall not make any law which takes away or abridges the rights conferred by this part. यानी ये बात करता है पोस्ट कॉन्स्टिट्यूशन लॉज के बारे में. Just the way Article 13 Clause 1 was talking about pre-constitutional laws, Article 13 Clause 2 talks about post-constitutional laws. यानी constitution के enactment and enforcement के बाद जितने भी सारे मॉडर्न लॉज आप देख रहे हैं, ऑल ऑफ दोज लॉज आर पोस्ट कॉन्स्टिट्यूशनल लॉज. आप प्रिवेंशन ऑफ सेक्सुअल हरासमेंट एक्ट देख लीजिए या तो फिर आधार एक्ट देख लीजिए, जितने भी लॉज देख रहे हैं, कंपनीज एक्ट, जितने भी लॉज देख रहे हैं, सब पोस्ट कॉन्स्टिट्यूशनल लॉज है. सो स्टेट कैन नॉट मेक एनी सच लॉ विच टेक्स अवे और अब्रिजेस द राइट्स, यानी स्टेट शुड नॉट बी मेकिंग एनी सच लॉ इन द फर्स्ट प्लेस which violates the fundamental rights of the citizens, या तो फिर any such law which curtails the rights of the citizens, then those laws which contravene the fundamental rights to the extent of such contravention shall be void. Yani this talks about doctrine of severability. Let us try to understand what doctrine of severability is through an example. से जैसे आर्टिकल 13 क्लॉज 1 में मैंने एग्जाम्पल दिया XYZ एक्ट का, सिमिलरली एक ऐसा पोस्ट कॉन्स्टिट्यूशनल लॉ है XYZ एक्ट जिसमें बहुत सारे प्रोविजंस है, सेक्शन 1, सेक्शन 2, ऐसे बहुत सारे सेक्शंस हैं, और उनमें से सेक्शन 2 एंड सेक्शन 3 वायलेट आर्टिकल 19 ऑफ द कॉन्स्टिट्यूशन. नाउ सच सेक्शन, दिस सेक्शन 2 एंड सेक्शन 3 which violate article 19, these shall be declared void, and after being declared void इसे सिवियर किया जाएगा फ्रॉम द मेन इनैक्टमेंट, यानी सेक्शन 2 एंड सेक्शन 3 को एकदम ही हटाया दिया जाएगा बिकॉज दे वायलेट द फंडामेंटल राइट्स. सो XYZ एक्ट को रिटेन किया जाएगा बट माइनस सेक्शन 2 एंड सेक्शन 3. सो द रेस्ट ऑफ द एक्ट रिमेन्स विदाउट दीज टू प्रोविजंस. But there is a caveat. If section 2 and section 3 were integral to this entire XYZ enactment, and without section 2 and section 3, the entire enactment makes no sense. तो फिर ये entire act को ही invalidate किया जाएगा. So now the act becomes bad in the eyes of law. But however, if this act makes sense and still retains its essence even without this section 2 and section 3, then the entire act will be retained. So that is what doctrine of severability is. That is any provision, any clause, any section or anything that contravenes the fundamental right, such provision shall be removed from the enactment, and while the rest of the enactment will be retained as long as it makes sense and has some value in the eyes of law. So before we take a look at Article 13 Clause 3, let us try to understand how normal laws are made. नॉर्मल लॉज यानी आप कोई भी इनैक्टमेंट या लेजिस्लेशन ले लीजिए, से फॉर एग्जांपल कंपनीज एक्ट, मटर्निटी बेनिफिट एक्ट, कंज्यूमर प्रोटेक्शन एक्ट एट्सेट्रा, ये सब लॉज है, लेजिस्लेशंस हैं. सो हाउ आर सच लॉज मेड? So first of all, The first thing is to bring a draft policy. That is, the lawmakers draft a framework, a broad skeleton of the future law. They do it by holding stakeholder consultation or public consultation. They refer to various experts and various academicians and various committees before drafting such policy. Now, after such policy has been drafted, it is introduced before the houses of the parliament. तब उसे बिल कहला जाता है. So, when this bill is introduced before the houses of the parliament, it will be discussed thoroughly and then put to vote. अगर ऐसे बिल पास हो जाता है by both the houses of the parliament, then it will be called an act, which is how we know our legislations. So before we take a look at Article 13 clause, so is there any other way of making laws? Yes, these are called ordinances, which have been discussed in Article 123 and 213. Ordinances are just like ordinary laws, but उनमें difference यही है that ordinary laws are made by the lawmakers and are passed in the houses of the parliament. लेकिन ordinances are promulgated by the president when neither Rajya Sabha nor Lok Sabha are in session, or both the houses are not in session. So if neither or either of the houses are not in session, then the president, if he or she feels that there is a necessity, an urgency that requires a law to be passed immediately, then the president can bring such ordinances, can promulgate such ordinances, which will have to be passed by the houses of the parliament when they come back in session. But this is just another way of making a law. So the president can do it under Article 123, and the governor can do the same. That is, he or she can also promulgate ordinances for the state under Article 213. अब चलिए आते हैं आर्टिकल 13 क्लॉज 3 में. आर्टिकल 13 क्लॉज 3 रीड्स एज इन दिस आर्टिकल unless the context otherwise requires, law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usages having in the territory of India the force of law. Laws in force includes laws passed or made by legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at all or in particular areas. So what you need to remember basically is Article 13 clause 3 defines what is first law and second what is laws in force. If you notice यहाँ पे it is an inclusive list, यानी it talks about what law includes. बट रिमेंबर ये एग्जॉस्टिव लिस्ट नहीं है. लॉ क्या है या हो सकता है दैट लेजिस्लेचर और जुडिशियरी एंड और जुडिशियरी में विद टाइम एक्सपैंड अपॉन, यानी दे कैन डिसाइड लॉ के अंदर क्या क्या और इंक्लूड हो सकता है. बट फिलहाल कॉन्स्टिट्यूशन में लॉज इंक्लूड्स ऑल द थिंग्स दैट हैव बीन मेंशन्ड इन 13 clause 3. Now I have already mentioned what normal legislations या enactment are and what ordinances are. So I will not define them here again. Rather जो बाकी definitions है such as order, bylaw, I will explain it now here. Let us first start with order. तो यहाँ पे एक चीज़ याद रखिएगा, यहाँ पे order का मतलब executive order and not any other kind of order. से फॉर एग्जाम्पल जुडिशियल ऑर्डर नहीं, ये सोली एग्जीक्यूटिव ऑर्डर की बात किया जा रहा है. सो व्हाट एग्जैक्टली इज सच एन एग्जीक्यूटिव ऑर्डर? ये बेसिकली एक इंस्ट्रक्शन है विच इज़ इशूड बाय द एग्जीक्यूटिव एडमिनिस्ट्रेशन एंड अथॉरिटी. जनरली इट्स साइंड बाय द प्रेसिडेंट और द गवर्नर. तो आप ये याद रखिए, ऑर्डर इज़ बेसिकली एन इंस्ट्रक्शन जो कि इज़ साइंड by one of the executive administration, generally by the president or the governor. Next are bylaws. So bylaws are basically secondary laws. यानी जो नॉर्मल लॉज है, जो जैसे लेजिस्लेशंस जिसके बारे में मैं बात कर रही थी, वो है प्राइमरी लॉज. बट bylaws are secondary laws which are established by an organization or a community, and such laws apply only to that organization or community, and these are established so as to they can so as to allow them to regulate themselves. So basically self regulation के लिए जो भी laws establish किया जाता है उन्हें bylaws कहा जाता है. Now coming to the definition of rule. Now as you'll remember previously I said that a normal legislation is basically a broad framework. यानी कोई भी मिनिस्ट्री किसी पर्टिकुलर चीज़ के ऊपर डिटेल में नहीं जाता है, बट एक ब्रॉड स्केलेटल ड्राफ्ट बनाता है जो पेश करते हैं वो पार्लियामेंट में और उसी को ही पास करते हैं. आपको मैं एग्जांपल देती हूँ. फॉर एग्जांपल मिनिस्ट्री ऑफ इंफॉर्मेशन एंड टेक्नोलॉजी, राइट. सो जस्ट टू रेगुलेट द internet, or say for example the telecom industry or whatever, or the information and technology sector, they have brought the Information and Technology Act, right? But the act does not go into the detail. वो कुछ basic definitions देते हैं about say for example intermediaries या information क्या है या technology क्या है, ऐसे basic definitions and other provisions, say for example penalties for cyber crimes, or for example talking about different cyber crimes. So the IT Act talks about such broad things. But the same ministry, that is the Ministry of Information and Technology, इसी act को properly implement करने के लिए they will bring the rules. दैट इज़ द एग्जीक्यूटिव. ये लेजिस्लेचर रूल्स नहीं बनाते, ये एग्जीक्यूटिव बनाते हैं रूल्स, और ये रूल्स बनाया जाता है टू प्रॉपरली इम्प्लीमेंट द एक्ट. तो अगर वो IT एक्ट है तो उसका कैसे इम्प्लीमेंटेशन होगा, दैट इज़ व्हाट द इंफॉर्मेशन एंड टेक्नोलॉजी रूल्स विल डिस्कस. रिमेंबर, ordinary legislation, that is an act, is a primary legislation, whereas a rule is a secondary legislation that is brought to properly implement the parent act. Now let's talk about regulations. Now as I've already said, अगर एक act बनता है तो उसको implement करने के लिए rules बनेंगे, and generally in such acts there is a statutory or a non-statutory body that is generally established. यानी सोचिए ह्यूमन राइट्स को इम्प्लीमेंट करने के लिए वी हैव नेशनल ह्यूमन राइट्स काउंसिल. तो अगर वो कोई एक्ट से बना हो, इफ़ द NHRC हैज़ बिन एस्टैब्लिश थ्रू एन एक्ट, देन द NHRC नीड्स टू बी रेगुलेटेड. यानी हाउ दैट पर्टिकुलर बॉडी विल बी वर्किंग और फंक्शनिंग, उसके लिए भी कुछ रूल्स होंगे. बट इसी रूल्स को रेगुलेशन कहा जाता है बिकॉज दीज रेगुलेट द बॉडी. यानी regulations are basically those part of the laws which regulate a statutory or a non-statutory body. Now notification is pretty simple. ये generally issue किया जाता है by the central or the state government to exercise the power of a legislative enactment. यानी notifications तब issue किया जाता है to lay down the law, to take care of some procedural part or aspect of the enactment. Yani if there is any procedural aspect of an enactment, then how to implement it, when and where, what will be the complete procedure, ये सब के लिए notification is issued to give in detail explanation or elaboration on such implementation or procedure. Now coming to the definition of custom and usage. Now we have to remember usage and custom, there is a very fine and a thin line between the two, and sometimes we interchangeably use them, but there is some difference, although there is a similarity, but there is a difference between the two. तो custom जो है वो basically एक traditional और widely accepted way है of behaving or doing something. And this is generally very specific to a particular community. यानी से फॉर एग्जाम्पल सप्तपदी, वो एक ऐसा रिचुअल है, वो एक कस्टम है दैट इज़ पर्टिकुलर टू हिंदू कम्युनिटी एंड इन हिंदू मैरिजेस. सिमिलरली एक यूसेज जो है is basically when repetition of acts arises and becomes the general rule. Yani, if I keep on doing something time and again, and this is something that happens in a society, so basically several individuals of a society keep on repeating or doing a particular act, then that becomes usage, and usage se hi arise karta hai customs. That is when such repetition of such acts become the general rule or law. So usage is basically the doing of such acts or the repetition of such acts, whereas custom is when such repetition of acts become the general rule for the society. So these are some broad definition, basic definitions of what these laws or different types of laws mean. Now, Article 13, Clause 3 does talk about what will be included in law. As I said, it's an inclusive list but not exhaustive. Yani, in future, court or that is the judiciary or the legislation can decide as to what may or may not constitute as law. But so far, अभी तक there are certain things that have been decided कि ये law नहीं बनेगा, or rather it will not constitute as laws. These do not have the effect of being law. तो इनमें तीन ठो चीज़ें हैं. फर्स्ट है कोर्ट ऑर्डर्स एंड जजमेंट्स, सेकेंड कॉन्स्टिट्यूशनल अमेंडमेंट्स, एंड थर्ड पर्सनल लॉज. So I'll talk about constitutional amendments later, but for now, let me tell you that court orders and judgments do not constitute as law. That has been clearly said by the judiciary. These do not have effect of law because law is essentially the work of that is the exercising of power by the legislature, and judiciary, which does not have the mandate of the people, cannot bring laws, but rather by giving such court orders and judgments decides the validity of the laws brought by the legislation. So as of now, court orders and judgments do not constitute as law. But एक और important चीज़ है, that is personal laws. So whether they constitute as laws or laws in force. So to understand whether personal laws fall under the definition of laws in Article 13, Clause 3 or not, we need to take a look at this case law, स्टेट ऑफ बॉम्बे वर्सेस नारासू अप्पा माली. ये बहुत ही इंपॉर्टेंट केस लॉ है जिसमें सुप्रीम कोर्ट ने डिसाइड किया दैट पर्सनल लॉज डू नॉट फॉल अंडर द डेफिनेशन ऑफ लॉज इन आर्टिकल 13 क्लॉज 3. इसका यही रीज़न दिया गया है दैट पर्सनल लॉज डू नॉट डिराइव देयर वैलिडिटी फ्रॉम लेजिस्लेचर, यानी लेजिस्लेचर नहीं बनाते हैं ये लॉज. If you will remember our discussion in the UCC video, we spoke in detail about what exactly are personal laws, but in a gist, personal laws वो laws होते हैं which are made by each religious or social or cultural community. यानी अगर हिंदू, मुस्लिम या सिख या क्रिश्चियन कोई भी कम्युनिटी अपने खुद के लॉज बनाते हैं टू रेगुलेट मैटर्स सच एज मैरिज, अडॉप्शन, डिवोर्स, इनहेरिटेंस एट्सेट्रा, तो वो उनके पर्सनल लॉज होते हैं एंड इसमें लेजिस्लेचर का कोई हाथ नहीं होता है. दैट इज़ लेजिस्लेचर डज नॉट मेक दीज लॉज, दीज आर एब्सोल्युटली पर्सनल टू द पर्टिकुलर कम्युनिटी इन क्वेश्चन. If you take a look at Article 13, Clause 3, वहाँ पे लिखा है laws in force includes laws passed or made by legislature or other competent authority in the territory of India. And if you'll remember, we had discussed in detail what other competent authority are or is in the Article 12 wala video mein. So we've discussed that in that particular video. But what we need to understand here is that laws in force बस वही लॉज होंगे जो लेजिस्लेचर या तो फिर अदर कॉम्पिटेंट अथॉरिटी ने बनाया है. तो उनके अलावा अगर कोई पर्सनल कोई कम्युनिटी बनाता है कोई पर्टिकुलर लॉज, तो दोज लॉज विल नॉट फॉल अंडर लॉज और लॉज इन फोर्स अंडर द डेफिनेशन इन आर्टिकल 13 क्लॉज 3. Now let us take a look at one of the most important clause, Article 13 clause 4. Nothing in this article shall apply to any amendment of this constitution made under Article 368. Yani, this basically says that constitutional amendments will not constitute or not fall under the definition of law. constitutional amendment has been discussed in Article 368 and, as has been clearly and explicitly mentioned, will not fall under the definition of law. So यहाँ पे we have to remember two doctrines that are very important. First is the doctrine of judicial review and the second is the doctrine of basic structure. Now, doctrine of basic structure, if you'll remember, has been propounded by the Supreme Court in the Kesavanand Bharati case. तो इस केस में सुप्रीम कोर्ट ने कहा दैट कॉन्स्टिट्यूशन में ऐसे कुछ प्रोविजंस, ऐसे कुछ आर्टिकल्स हैं जो बहुत ही इंपॉर्टेंट है एंड आर वेरी इंटीग्रल टू अपहोल्डिंग द राइट्स ऑफ द सिटीजन और अपहोल्डिंग द कॉन्स्टिट्यूशन इन itself. The legislature or the executive cannot take any action or cannot pass any enactment or any legislation which will curtail or abrogate or take away these particular provisions or reduce the importance of such provisions or articles of the Constitution. Supreme Court said that the basic structure constitutes of those principles which are or which uphold the very essence of the Constitution. Yani, say for example, the principles of federalism or the principles of upholding the right to life and liberty and equality, etc. ये सब बहुत ही important है in letting the Constitution function actively and properly. And therefore, these cannot be amended to the point where it hurts the rights of the citizens. Then comes the doctrine of judicial review. Now, judicial review was evolved by the US, that is United States of America, judiciary, but this has been adopted by the Supreme Courts and the High Courts of India. Now, judicial review has not been explicitly mentioned, as in ये term को explicitly mention नहीं किया गया है, but Article 13 does expressly talk about it. So remember this, that Article 13 expressly talks about judicial review but does not explicitly mention the term judicial review. Now, judicial review is basically, the idea is that the higher judiciary, yani Supreme Court and High Courts of India, can look into any legislative or executive or administrative action that has been taken and can determine whether such actions go against the fundamental rights or whether it violates the right of any citizen. And accordingly, if any such action does violate any right, then the higher authority, that is the higher judiciary, yani Supreme Court or High Court, can declare such law or orders by the executive as null and void or unconstitutional. So that is the idea of judicial review, that is review by the judiciary as to whether legislative or executive actions are constitutional or not. Now, if we take a look at all the landmark case laws which dealt with constitutional amendments and fundamental rights and whether constitutional amendments fall under the definition of law or not, first is the case of Shankari Prasad versus Union of India, जिसमें the Supreme Court said that law includes only ordinary laws or enactments that are passed by the legislature and does not include constitutional amendment. और साथ ही साथ सुप्रीम कोर्ट ये भी कहा that the power to amend constitution under Article 368 also includes the power to amend fundamental rights. Then is the case of Golaknath versus State of Punjab. Here, the Supreme Court implied that, in a sense, amendments, that is, constitutional amendments, could fall under the definition of law and could be declared void if they violated the provisions of Article 13. That also the constitutional amendments should not have the power to curtail the fundamental rights of Indian citizens. ये याद रखिएगा that during Shankari Prasad and Golaknath, Article 13 Clause 4 was not inserted, due to which the debate of whether constitutional amendments fall under the definition of law or not arose. But this was cleared by the 24th Constitutional Amendment 1971, which inserted Article 13 Clause 4, which explicitly stated that constitutional amendments will not fall under the definition of law. इसका ये मतलब है that judicial review powers of the higher courts will not apply to constitutional amendments and that the legislature can dilute the constitution, यानी constitution को weaken कर सकते हैं by making amendments which affect the fundamental rights of the citizen. But lastly, it was in the Kesavanand Bharati case versus State of Kerala, where the Supreme Court held that Article 368, yani constitutional amendments, will fall under the definition of law, and that if any constitutional amendment takes away or abridges or curtails fundamental rights conferred by Part 3 of the Constitution, it will be considered as void or unconstitutional. So let's do a quick revision of everything that we have studied till now. So if we take a look at Article 13, तो ये basically यही कहता है what it defines what are laws, what includes laws, what are laws in force, and it talks about what happens when laws are inconsistent with fundamental rights. यानी कोई भी law अगर enact किया गया and it violates the fundamental rights, then what happens to it? So 13 clause 1 says that whatever pre-constitutional laws, that is laws that were made before the constitution, whichever pre-constitutional laws are inconsistent with the part 3 of the constitution shall be eclipsed. If you remember doctrine of eclipse, yani that law for the time being will be overshadowed until and unless an amendment is brought to amend either the law or the fundamental rights, and the law becomes consistent with the fundamental right, or rather the part 3 of the constitution. Then Article 13 clause 2, which talks about post-constitutional laws, that is laws that were made after the enactment of the constitution. So those laws that the states make can't be violative of the fundamental right. The states are not supposed to make any law which curtails or takes away the fundamental rights of citizens or goes against part 3 of the constitution. Or agar if state even brings such laws, then the doctrine of severability will apply. That is, all those provisions of that particular law which contravene the part 3 of the constitution, those laws will be severed, yani hataya diya jayega. Then Article 13 clause 3, which talks about law as its definition of law, what law includes basically. And as I've already told you, that it includes ordinance, order, bylaw, rule, regulation, notification, custom और usages. याद रखिएगा कि ये एग्जॉस्टिव लिस्ट नहीं है, यानी लॉ में और भी बहुत कुछ आ सकते हैं. दैट विल बी एज इन व्हेन लेजिस्लेचर और द जुडिशरी डिफाइंस इट एज. So laws in force also is included in this, and laws in force means all those laws which are made by legislature or any other competent authority that have mentioned in Article 12 wala video mein. Also remember Article 13 clause 3 mein we have discussed doctrine of basic structure, which was propounded in Kesavanand Bharati case, as well as doctrine of judicial review. And as I've told you, do remember that judicial review has been expressly provided in Article 13, but इसे explicitly mention नहीं किया गया. So if there is a question whether Constitution defines judicial review, remember the answer is no. Then ultimately is the Article 13 clause 4, which talks about constitutional amendments under Article 368, whether they are law or not. So 13 clause 4 says that constitutional amendments are not laws. Lekin as we have discussed the progression of the case laws from Shankari Prasad to Golaknath, then the 24th constitutional amendment to finally Kesavanand Bharati case. So ultimately what can we conclude with regards to constitutional amendments under Article 369? So what we can conclude is simply is this, that constitutional amendments are not laws according to Article 13 clause 4. Lekin as per the judgment of Kesavanand Bharati, what the Supreme Court has said is that doctrine of judicial review will apply to such constitutional amendments if it violates the basic structure of the Constitution. As I've mentioned, that basic structure of the Constitution consists of those principles which are absolutely integral and which uphold the essence of the Constitution. तो अगर कोई भी कॉन्स्टिट्यूशनल अमेंडमेंट लाया जाता है विच गोज़ अगेंस्ट सच प्रिंसिपल्स, विच गोज़ अगेंस्ट द बेसिक स्ट्रक्चर ऑफ द कॉन्स्टिट्यूशन, then the doctrine of judicial review will apply, and the judiciary can declare such amendments as null and void. So this brings us to the end of our video. I hope you found this video helpful and informative. Hopefully it will help you in your preparation for prelims as well as mains. We do have a request again. If you like our content, do like, share and subscribe Exact Eyes on YouTube and follow us on Instagram. Thank you so much for watching. I'll see you guys in our next video.